court should decide that a landlord should not be held to the same liability for the acts of a tenant that employers are held for acts of an employee. Further, a hostile housing environment should not be based on a landlord's failure to take action to stop harassment by one tenant by another. There are two reasons why each of these conclusions should be reached. This court should affirm the dismissal of claims because the Fair Housing Act should not be expanded to post-acquisition. And secondly, a landlord is not liable for their failure to prevent harassment between tenants and has not created a hostile housing environment by failing to do so. As stated above, the decision by the district court to dismiss the complaint in favor of Tyler Properties should be upheld because Section 3604 should not be expanded to post-acquisition housing. A majority of courts considering the issues of whether the Fair Housing Act should be expanded to include post-acquisition have found 3604B is limited to discrimination in the provision of services as they're connected to the acquisition, sale, or rental of housing. This decision has resulted in the conclusion that if the challenged discriminatory activity occurs after a buyer has purchased the property and if the activity is not one which results in actual or constructive deprivation, the activity is not prohibited by the Fair Housing Act. Further, the Fair Housing Act does not contain a hint in either its language or its legislative history of concern with anything but strictly access to housing.
Can you give an example of under your argument, the provision of services or facilities has to reference pre-acquisition sale or rental, right? In order for the statutory language to not extend the way your opponent wants it to. So can you give us an example of a service or, not a service, but can you give an example of a facility that relates to the pre-acquisition sale or rental? Because, I mean, that word's got to mean something, right? We don't interpret words out of the statute.
Yes, Your Honor. I would say, in looking at the language and the provision of services or facilities in connection therewith, it could, the term facilities could apply to being able to come to the landlord's office and not being discriminated on those terms. And also in looking at the language of the section, as I said, it prohibits conduct only insofar as it relates to or is in connection with the sale or rental of a dwelling and nothing past that in post-acquisition. So the plain meaning of this prohibition of discrimination does not relate to activities that take place after the individual has taken either ownership or leasehold of the property. And some opposing courts have held that 3604B separates post-acquisition discrimination in the rental context, and that if it is separated, it's inconsistent with the intent and the spirit of the Fair Housing Act. But if the law were written for this phrase to specifically apply, other than in the relation of rental or selling of a dwelling, Congress would have specifically written it in that fashion. If a rental of a property were to be distinguished to represent an ongoing relationship, it seems that those terms would have been used by Congress, included in the distinction of the language of the Act. Further, in analyzing the legislative intent, the clear intent of the legislature in creating the Fair Housing Act is to provide within constitutional limitations for fair housing. The Seventh Circuit, in deciding Halprin, looked at the legislative history and found that it was geared purely at preventing discrimination in the context of sale or acquisition of housing only, and that Congress never intended for it to be a catch-all discrimination law. The court specifically said they don't think that Congress wanted to convert every quarrel among neighbors in which a racial or religious slur is hurled into a federal case. Specifically, behind the Act lay the intent of the practice of refusing to sell to minorities in residential areas. Since the focus was on the inclusion of those minorities, the problem of how they were treated once they were included was not at the forefront of congressional thinking when they were developing this Act. There is nothing to suggest that Congress was trying to solve this future problem of what would happen to tenants once they were included and if they were discriminated against. this would have been an endeavor that required careful drafting in order to make sure that quarrels between neighbors were not thrown into federal court, and that was just not what the intent of the act was.
Isn't there some statement in the purpose section as originally drafted that shows that the statute was intended to cover occupancy?
Yes, Your Honor, it was included the word occupancy was at one point included in the act and then was taken out, which I think just furthers the point that occupancy is not part of it. If Congress intended it for it to be part of the act, it would have kept that word and that term in there for further distinction in the act.
But isn't your interpretation somewhat absurd? You're saying that a landlord can't discriminate against someone when they're first applying for access to reside at a certain place, but then once they do live there, then the landlord has free reign to allow harassment or discrimination or even discriminate against the tenant itself.
I see your point, Your Honor, but in this case, if there have been situations in the relationship Title VII to a hostile housing environment where a landlord is directly liable for the discrimination and they've been held liable in those cases. This case is distinguished from that because the landlord was in no way coercing, threatening, interfering with the clothes in their use and enjoyment of their property. Addressing the claim of the hostile housing environment being created by Tyler Properties' inaction and stopping harassment, the court should truly find that a landlord is not liable for their failure to prevent harassment between tenants. They haven't created a hostile housing environment by failing to do so.
Don't we put, this is like one out towards here, isn't there some duty on the landlord to provide like physical safety in the common areas of the building? Right, I think there is. Let's assume that there is. If that's the case, I mean, isn't this the same concept? That doesn't imposing the duty to address this severe and pervasive harassment just go to the same thing, that the safety, whether it's physical, mental, emotional, of the tenants in the building? Well, I mean, what's the difference?
I would say that in relation to agency law, there is a difference between the landlord being responsible for another tenant's action or the landlord prohibiting maybe someone off the property from coming in and robbing their tenants or having the safety of their tenants in the forefront of their mind. I would say that in agency law, the concept of that is that there's a consensual relationship in which one person is responsible for the other, which is what you just pointed out. But with the landlord-tenant relationship, I think that vastly differs from the employer-employee relationship, which is what the CLOs are trying to relate it to in terms of Title VII.
What's the difference? I agree that just like in your gut, there's something different about my relationship with my boss and my relationship with my landlord. But how do we articulate what that difference is? We make employers responsible. My employer has to address my coworker harassing me. Why doesn't my landlord?
I would say that landlords are not the employers of tenants, and so they seemingly have a little less control over the actions of tenants in their day-to-day lives than an employer has over their employees. They're also, the amount of control that a landlord exercises over the tenant is not comparable to what an employer has over the employee. There's an absent duty of control between the landlord and the tenant, especially the landlord, a tenant, and a third party as well. A reasonable opportunity to control a third party does not arise from the landlord's power to evict the party, and the landlord thus has no responsibility to third persons for the actions committed by that third person by another tenant. So I would say for these reasons, the appellant's claim should be dismissed and that the court should affirm the lower court's order. Thank you.
Thank you.